Hi, welcome to Commercial Law Tutorials. Under the topic Law of Contract, we have already looked at the definition and formation, even essentials of a contract. We have also covered lesson number 2, which is on offer and acceptance. Right now I am moving on to lesson number 3, which is on advertisement. In this lesson, we will define what advertisements are. Then we will explain the types of adverts in law. Lastly, we will look at questions relating to this lesson. First of all, the definition. Advertising is a marketing tactic involving paying for space, that is television, radio, magazine, to promote a product, service, or a cause. The goal of advertising is to reach people most likely to be willing to pay for a company's products or services and entice them to buy. So in general, a public advertisement is not an offer, but merely an invitation to make an offer, unless there is a reward attached. Now let us look at the classes of adverts we have. The first one is the invitation to do business. For example, displays in window shops. In general, displays in window shops are mere invitations to do business and not offers. They are treats. The display of goods with a price ticket attached in a shop window or on a supermarket shelf is not an offer to sell, but an invitation for customers to make an offer to buy. So, display of goods in a shop window with prices marked upon them is an invitation to offer only. Shop induces another person, that is the customer, to make an offer to the shop. It is known as invitation to offer. Similarly, in the cases of a self-service shop, price lists, tenders at auctions, and catalogs, they are all invitations. Offer and acceptance will now take place at the time when the customer tenders the price to the cashier. The customer makes the offer to buy the product, which can be accepted or rejected by the tradesman or the cashier. For example, refusal to sell beer to an underage boy. As such, it will not be breach of any contract when the advertiser refuses to sell an item at a price he or she advertised. For instance, in this case, a shopkeeper in Johannesburg advertised a particular brand of tobacco at a cheap price, having a placard outside this shop on which the price was shown. Crawley entered the shop, bought a pound of tobacco and left. He then re-entered the shop and asked for another pound. The shopkeeper refused. Crawley refused to leave the shop without the tobacco. The advertisement was not an offer, and a contract was not there. Therefore, it was concluded that when Crawley tendered the price, Crawley was making the offer. Crawley had been rightly convicted under law for not leaving the premises when requested. The second class we have is an offer. A contract of reward, like any contract, must be supported by consideration, something of value. Unless a statute requires the offer to be in writing, the offer of reward can be made orally. An offer is made by advertisement to do business with whomever shall perform certain acts. For example, the offer of a reward for the giving of information or the doing of a certain act, like exchanging old books for money. In such a case, the offer is accepted and as a result binds the offerer contractually to the first person giving the information or doing the act required. Offer can be made to a particular person, to a class of persons, or even to the whole world. For example, offers for information on lost items or on criminals. Some advert offers have due dates, but if an offer of rewards has no time limit, it is considered to have expired or withdrawn after a reasonable time. A reward can be claimed only by a person who has complied with the conditions of the offer before it expires or is revoked. Performance can be completed by a third person, such as an agent or a servant, who is acting on behalf of the claimant's interest. The general rule, though, is that the person who claims the reward must have performed the services knowing of the offer and for the purpose of collecting the reward. When a reward is offered to the public, anyone who performs the required service can claim and accept the reward, except persons who are under a duty to perform such services, like police officers cannot get a reward for locating a criminal. So, we'll look at this case where a company put up an advert in the press that the company would reward any person the sum of £500 for the information given to the CID, leading to the arrest of thieves and recovery of the stolen property. Bloom supplied the information in ignorance of the offer, and afterwards, having heard of it, he claimed the reward. Bloom was unsuccessful. It was held that Bloom, who supplied the information, which led to the arrest of the thieves and recovery of the jeweler, did not at the time know of the existence of the offer. Therefore, he could not recover, because when he performed the act prescribed, he didn't know about the reward. So, if anyone gives the information and forgets to even ask the reward, go and then come back and ask for the reward, that person is not given the reward. Upon giving the information, the person should also ask for the reward there and then. Now, besides cases of reward, courts also consider the following adverts as offers. The advertisements with sufficient definite terms, for example, description, quality, quantity, and price. Then the advertisements targeted at a specific person or group, usually a limited group of people. For example, an advertisement telling those with old books to exchange the books for money. The circumstances of publishing the advertisement clearly show that advertiser intends to offer a contract, for example, in job offers. Now the questions: is an advertisement an offer or an invitation to treat? Discuss. In what cases can an advertisement be considered an offer? Thank you so much for watching. Please subscribe if you haven't done so that you won't miss any videos I post. Then also remember to like and comment.